So welcome. With a little delay, but nevertheless, we are here united in a jazz club on a stage. It smells a bit old beer, I think. Brings us all in the mood for a very, very important topic we want to discuss today, because we want to discuss how detailed should a summary of the data that was used in the training of general purpose AI under the AI Act be. And I have a really, really wonderful panel. I'm happy to introduce you very briefly to the panel. I'm Kristina Irion, I'm the moderator. I'm an associate professor at the Institute for Information Law in Amsterdam. Next to me, I have Lucie-Aimée Kaffee. She joins us from Berlin, and she is the EU policy lead at Hugging Face, and she is also an applied researcher. And her research interest in her work is on the intersection of policy and AI technology. Who would have thought that? And her research focuses on harnessing AI to support online communities, in particular Wikipedia. Next to Lucie, we have Arriën Molema. He is a musician and a composer, and as if this is not enough, on top of it, a board member of various songwriter-related organizations in the Netherlands. And Arriën is, for example, an executive board member of the International Council of Music Creators, CIAM. And if you want to check out his band, for example, Room 11, on his website, you can hear some really cool sounds. Next to Arriën, we have from the European Commission, I'm very happy to have you on the panel, Yordanka Ivanova. She is the head of sector legal oversight of the AI Act implementation in the unit that is responsible for AI regulation and compliance of the European Commission's AI office. And as this head of sector, she is responsible for overseeing and coordinating the legal implementation of the AI Act, including also preparing a template for the summary of training content for general purpose AI models that would, once this summary is published, then also be the template for the general purpose AI model providers and operators to publish the data. Okay, and then, last but certainly not least, Zuzanna Warso. She is from Open Futures. She joins us from Warso, and she is the director of research at Open Future, and she really has doing a lot of impactful research recently. She's highly specialized on this topic, and with over 10 years experience with human rights research and advocacy, she is going to explain us, I'm sure, why this AI summary is such an important tool also for understanding how this general purpose AI model has been trained. And with this, I think we want to start the panel right away with some introduction. I give you just a few lines because I think it matters to set the scene a little bit. Many of you will be aware that the AI Act has a requirement that only is applying to general purpose AI models. And in this requirement, it says that some data should be published about how this AI model was trained, on which data. And it's a bit vague, but in the recitals we find a bit more of an explanation that says that it should be a sufficiently detailed summary. And all the details of this summary are then delegated or will become specified in a delegated act that the AI office at the European Commission is currently finalizing, I understand. And why do we need that? Because we have heard in the past from news reports, also from revelations, that a lot of data has been simply grabbed from the open internet, but also from platforms that have a totally different purpose, like social media networks, and that this data is fed into the training of general purpose AI models, sometimes regardless of the legal situation. So it's not always clear if, for example, copyright protected content can be used in this context lawfully, and whether the text and data mining provision that we have currently in EU copyright law would actually exempt this use of copyright protected works for AI training. But we are also all as individuals concerned here, because also our personal data is often used for AI training, and we have heard, for example, from the plans that X had to train Groks on Twitter data, but also right now, just in the previous panel, we heard that Meta has created an opt-out form for all its social media platforms like Instagram, Facebook, I don't know who's still on Facebook, and also WhatsApp if it's public messages, and that they want to also ingest that into training their artificial intelligence. And so users can opt out, but it is actually not sure if that is in line with the General Data Protection Regulation. So this is the setup, and with this I would very much like to hear the initial statements from these panelists about it. And we start with Yordanka, since you are at the source, so to speak, of this template.
Thank you very much. Do you hear me well? Okay, so thank you very much indeed for inviting me at this panel. You very well summarized the topic and the obligation that applies to all general purpose AI model providers. And there are key important elements there in this obligation that were already mentioned, but I just want a bit to emphasize, to explain a bit the complexity of the exercise, that rightly we as the AI office now are mandated to prepare a template for this summary of training data that general purpose AI model providers have used when they place also on the European market, that should be also published. So it has to be made publicly available. And it is still a summary, but it has to be sufficiently detailed. So, and there is the open question, how many details should be put there? There are important clarifications, indeed, in the recitals, in the intent of the co-legislators when they gave us this important task, that first we do have to aim to achieve that with this summary, we have to facilitate the exercise of the rights of legitimate parties, including right holders, but as you rightly said, also other parties. So we don't draw distinction only between copyright protected content or not, but aim to facilitate as much as possible the rights of any legitimate party whose data has been used, but even more broadly to increase transparency. At the same time, we have to take due account of the need to protect trade secrets, because as we know, training data is actually one of the key competitive advantages for the providers. If we see now, I'm very happy we have the open source community that is promoting more openness in general about the models, but including for the training data. But we see that there is clearly very much opacity on what data has been used currently on the market. And many concerns do exist from the providers about disclosing concrete details, including more specific curation and other methodologies, but even the training sources themselves. And our template at the same time have to be for this summary, so it has to be only summary, and it has to allow that this is this information about the training data is reported in a simple, effective way, also in a narrative format, non-technically detailed, but still comprehensive in scope. So, and then all the different groups now see different things with these constraints, but we've organized already a few consultations already over the summer, seeing a bit the starking divergences between the views, where indeed providers consider much of the data and don't want to share details about it, even about general description. On the other hand, we've seen a lot of strong concerns from right holders who want explicit work-by-work disclosure for each individual items, which somehow is not completely aligned with this idea of summary and then simple way of implementing it. So we've put a first proposal in January outlining some ideas how this we could try to find a balance on this, yeah, what we can say, there is some, at least some understanding, more growing understanding, and we are from the provider side and readiness a bit to disclose some more generic information as we have proposed, but when we go into the even information about certain specific types of sources, even whether in a very generic manner, for example, the scraped online content or content from private data sets, there are still a lot of concerns, and certainly even not wish to disclose even more details like top domain names, or something more generic. And now we are having this, analyzing this stakeholder feedback, and we plan to, continue to work to try to find this difficult balance and then propose the template. But this stakeholder input is really important for us, and we continue the reflection.
Thank you so much. And what is the timeline roughly now?
Yes, the timeline, so we have the obligations that we will apply as of 2nd of August this year, and we are internally working, because there is also a parallel work stream also on code of practice, that it's important to mention that it's not only transparency, but there is also other provisions that can also help implement the copyright. There is an obligation for a copyright policy as part of this code of practice, so it's an additional complementary, and then still the two processes are being finalized. The other one is more led by independent chair, the chair is still stakeholder driven, but we aim to finalize them clearly before the application of the rules, but because the importance of the topic, there are some delays on both sides to make it right as a final deliverable.
That makes this panel so timely. Thank you very much. Arriën, as a musician, as a songwriter, and of course also in your function as representative of organizations of artists, how does the transparency of training data affects you?
Thanks for having me, by the way. And indeed, I talk from the creator perspective, and usually people say copyright. I like to say, especially since we're in Brussels in Europe, author's rights, which is a big difference because it's vested in the human creator. What's kind of ironic in this whole situation is that we have the balance between trade secrets and transparency. And ironic from my perspective, at least, is that apparently the data that's being trained on is commercially valuable enough to be protected under trade secrets, but not commercially valuable enough to license or to give me a remuneration as a creator, which is kind of ironic or sad, however you want to call it. This makes it complicated for us. So I understand the balance. I don't envy your position, by the way. It's a complicated position to keep the balance in check. And from the author's right perspective, we have historically, we have couple of things that work in our advantage, which is prior authorization and the abstaining from unauthorized use. So those are the powers we have within authors' rights. And for me as a creator, I need to see on an individual level, I need to see that those rights are respected. I need to be able to check that. And that's why the opt-out is being put in place, not necessarily to be opting out all music for training, but to be able, as a rights reservation mechanism, to come up with a licensing system so we can get remunerated, which is to be honest, one of the fundamental human rights as well in the Universal Declaration of Human Rights, in other treaties. So we need that kind of clarity and transparency to be able to detect what is being put in there, whether an opt-out is respected. So that's why we lean towards the transparency side. And now it seems a little bit like a cloak and dagger game whereby AI models use trade secret arguments to basically say we can't disclose whatever we've been training on the works, but it feels a little bit more like a liability or an accountability question, because as we all know, everything has been scraped yet, and there's been no respect for the distinction between open databases and commercial databases. Privacy rights, whatever data is in there, it has been scraped. Zuckerberg has been, telling his people to scrape YouTube, I think, or another database, or probably multi-databases, without any prior authorization. So it feels like a cloak and dagger game whereby the trade secret argument is being used against transparency, but it is a cover-up to not be held liable, basically. So that is my personal individual perspective as a creator. I think there is also another element that's quite relevant and that's the cultural diversity element, because AI models are probability machines, basically, and therefore very quickly able to generate some sort of a cultural hegemony, like a dominant culture is easily being reproduced and echo chambered into that system, which can be, of course, a fine choice. There's nothing wrong with that, as long as we know what's happening in the black box, so what is being trained on. And I'm saying this from also from a human rights perspective, and I think it's even in the European Charter of Fundamental Rights. Somebody has written that, but it is in there that we should respect cultural diversity, and by that we also mean that we don't want to have only dominant cultures being echo chambered. So from a more collective perspective, I think it's important that we realize and see what's happening in that training data, and we need that level of data to see what is being used. Is there enough usage of culturally diverse, non-dominant cultures being put in there as well, I would say. So that's why I lean slightly towards the transparency side, I would say. Yeah.
Thank you so much. An impressive new argument for me, the cultural diversity in this context. It's very good. Let me go to Zuzanna. Zuzanna, you have worked on this topic for a while. So what do you say is really necessary, like in order to make such a summary meaningful?
Yes, thank you for having me. And just before I jump into the template topic, I just want to recall two things that I've heard yesterday that I think are very relevant also for this discussion. So the first thing came up during the panel on energy and the use of other resources for AI and for data centers. And then we heard how AI developers are pushing back against disclosing any information about the energy use that their models need. So we see this tendency, and this is of course not surprising, of trying to hide any sort of information about the use of resources, and it applies both to natural resources and data. And the other thing I've heard yesterday came from a industry representative from Estonia who said that we solve problems through transparency. And of course, transparency is not an aim in itself; it's a tool. But I think we should try to remember that really transparency can help us solve problems. And when we think that it does not serve that purpose, let's look closer at the arguments against it. But okay, so going back to the template and the sufficiently detailed summary, how many of you have seen the template, the blueprint that Open Future published together with Mozilla? Okay, some of you have seen it, some of you haven't seen it. So if you Google or use some other browser search to look it up, you can put sufficiently detailed Open Future and you'll find it. So basically, we realized sometime last year that we have that provision in the AI Act that actually is one of the few avenues for meaningful transparency of the training data. And we decided that the most impactful way of dealing with that would be to basically come up with a proposal, specific proposal that we can put on the table, that we can send to the AI office, and say, okay, this is our idea how this should be unpacked, and what do you think? So in that exercise, we started first of all with unpacking what other legitimate interests, what other rights, fundamental rights are there at stake, because of course there's copyright, as we all know, and the AI Act, as we already heard, is explicit about that, but there are also other rights. And the protection of personal data is the first thing that comes to everyone's mind, and you all are personal data protection geeks, so I will not go too much into that. We can have a discussion about, for example, whether the fact that the data is only stored and the model does not produce the personal data is already an infringement. I'd say yes, right? It already interferes with my privacy. That somebody has my personal data. It already should allow me to be able to exercise my rights, for example, to erasure or access or correction. But then, besides the protection of personal data and copyright, there's other legitimate interests. There are other rights at stake, and my darling is the right to science and academic freedom. This is somewhat unusual suspect here, because we in no way are saying that or thinking that the right to science, which is protected by fundamental rights, by the Charter, but also European Convention on Human Rights, it does not require private parties such as AI providers to share AI training data. However, it does create an obligation for the state to set up an environment that would allow scientific community to exercise their rights. And we believe access to information about the training data is necessary for scientists, for researchers to carry out scientific reviews, apply scientific scrutiny, which we need to know if the systems that we use are basically reliable, if they can be used in specific contexts where they are used. And this brings me to the issue of cultural diversity. I absolutely agree with what has been said. The right to not to be discriminated is also protected under the Fundamental Rights Charter. And for example, when we know that a public institution is using an LLM, we should be able to know also what data was used to train it, because we need this knowledge to be able to assess if the outputs might discriminate certain group, if the training data was representative or not. And there are other rights that are at stake that we refer to in our policy brief and then the blueprint. But all of that made us structure the proposal in a specific way. And without going too much into detail, you can, as I said, take a look at it, and we can discuss it later on. We basically structured it in several sections. We think that the following information is necessary for the summary to be a meaningful tool and not just a bureaucratic exercise. And this is the overall size of the data, information about the data sets and their sources, because we need to know, for example, in order to address the argument of trade secret, if the data is publicly available, there's no discussion if it's trade secret or not, right? If it's publicly available, it's not secret, and that's one of the conditions for protection of trade secret. Then information about data diversity and some information about the data processing. For example, because if we know that the data has been anonymized, we can assume that our personal data is not there. But if the data has not been anonymized, then this raises concerns related to the protection of personal data. I'll finish here.
Oh, thank you so much. But I also understand that you are asking in the template that some of the procedures that have been applied to the data sets, that you argue that this should also be disclosed. How has the data been treated in the pre-processing?
Yes, indeed. For example, information about filtering is important to know whether some toxic or harmful information has been filtered out, which then can help us in deciding if a model can be used in a specific context, for example, whether children should be able to use it or not.
Thank you so much. Which brings me to you. I'm very happy that we have somebody who actually really does it, yeah? Because I think from that perspective, we understand also better the implications and maybe the arguments. Is transparency an issue for your company? I don't think so, because you say open source is the guiding principle, right?
Definitely. So to give a bit of context, Hugging Face is now the most widely used platforms for sharing models, training data, evaluation. So we have this like super big open source AI developers community. Does it work? Okay. We have the big open source AI developers community that kind of comes to this platform and exchange their AI artifacts. So, as I said, models, training data, evaluation data, and so on. There's courses. We try to, basically the idea is to lower the burden or the entry level to AI development and create this like very diverse community of model developers. In the context of the AI Act, we count also as model developer because we do fully open source models, meaning we did for example, our science team did a full open source reproduction of DeepSeek, meaning the training data, the code, as well as the model weights, of course, are all accessible. So for our models that we develop, our AI models, of course, transparency isn't that much of a question. It's all out there anyway, including our data. And I think this is also a little bit where we can look at when we talk about those templates. And when I looked at the template that Open Future suggested or Zuzanna suggested, we had always this thing in our minds where we were like, well, the open source community is already doing that. Maybe for a different purpose. The documentation in the open source world, of course, is for other developers, like what is this data set, what do I do with it? But questions about filtering of the data for toxic content, for example, bias, how has this been used, where does it come from, are all things that are very standard to document in the context of open source. So we know it's technically possible, and it's not just possible, even if you do it inside your own company, a lot of this is just good practice. Like I also am an AI developer by training, basically. So you just document your data. That's like a very standard thing to do. One of the concerns that we, of course, have when we look at the transparency template is not just the template itself. Of course, there's a lot of questions of, is this more made for like closed sourced models or with closed source models in mind? How is this applicable for open source developers? How does it integrate into their existing workflow? Are we putting an additional burden on them when their data already is open source and they already have a template that they've been using and they're used to? But I think another really important question when it comes to that transparency template and why I'm arguing for as thorough of a transparency template as possible is that we don't want to get into a situation where we accidentally penalize open data providers. So there is this thing where now on the hub, like that's the Hugging Face platform basically, you will look for data sets and you will find all kinds of data sets. So if you're a researcher or you're just starting in AI development, but even for large companies, those data sets are the standard. Like that's what we've been using, that's how AI has been developed, and especially in the European context, it allows us to share data sets that are for lesser resourced languages, that are not as common, where we can run first experiments across all the European languages, for example, or train an existing model for a specific language. When we close up the data sets, when we say there is documentation, but the copyright holders, for example, cannot really enforce their right for copyright on those closed data sets, what's happening already is that they go first to the open source or the open data providers, because that's where they can actually look into where is my data here, how much of my data has been used, who is using it, who's republishing my images. And what we're doing then is that we're discouraging the open sharing of data. And that is crucial. I think that's a really, really important point that we tend to overlook, because it is crucial in the European context that now we're talking about how do we compete in the international context, how do we build sovereignty. We cannot do any of those things without the data. And if the only data we're penalizing, again, is the open data, we are encouraging researchers, small data providers, open data providers to just keep their data sets behind locked doors. And we're in a situation that we were in when in 2017 I started my PhD, where people would share zip files of data sets via emails because they're not quite sure where we could upload those and if that brings legal consequences. And I think this is really, really crucial to clarify. Again, from a developer's perspective, I think to be able to take responsibility for the system they're creating, and we cannot never decouple the model risk without the deployment context, like where do we deploy the model and how is this risk then influenced by the model. You need transparency. You need to know what is in those data sets. And I think that goes much larger nowadays than just the model itself, because people often use systems like APIs, right? AI systems where there's some model inside, and so they don't have the downstream provider right to understand what was in that model. They just would have the publicly accessible documentation of the training data. And for them also to be able to take responsibility, accountability, and talk about how does their system work, what's in there, what might be flaws of the system. It's really important to have as detailed of a documentation as possible, including, for example, evaluations around bias and so on. I think that would be my main points. Thank you.
Oh, thank you so much. I understand correctly that under good practices, this documentation would be there anyway, because data quality practices, I understand, require having this documentation of in order to be able to also then improve the model or add additional data sets and so on, yeah?
A lot of it. I wouldn't say every single part of the Open Future template, but we did look into, from our models, we looked into what open models would provide anyway. So for one of our models, we just tried to implement that template. And in the implementation, we found that we did not need to run anything additionally across the data sets. That was all around anyway, because there's a lot of documentation, again, for a different purpose, for reuse, not for transparency. But somewhere across all those documentations, a lot of that already exists.
Thank you. So now I publish my work a lot under CC BY licenses. This is a copy, and a license that allows the non-commercial reuse of my academic work. And I don't know, but I would assume that all my articles and all my open source work is already part of some sort of training data set, yeah? But is that then actually non-commercial, I ask myself, especially when this goes into the pipeline of one of the big tech companies? And how would I ever know about it? Because, frankly, I never got an information that that this or that database became now part of model training. Although some of the publishers change sometimes now their contracts to allow exactly that. Let me continue back. Where have you published your music, let's say, and are you aware if this music is actually already used for training AI, or have you get any information about that?
And by publish, you mean where it's out there?
Mm-hmm.
Yeah, well, it's. I think it's on all platforms. So the biggest one in Europe is Spotify and Deezer. I think it's on there. It's on YouTube. So yes, it has been scraped. I don't think anybody in the music sector thinks that their music is not scraped at this point. So that's sort of like we're running a little bit behind the actual issue because it's already taken place. And there was a second question. Sorry, I forgot that.
Yeah, I wanted to know if you received any notification
yes.
from, for example, Spotify. I don't know if they
No.
already used that.
No, what I've done is I've tried with OpenAI, ChatGPT myself to extract a little lyrics based on my own music, and it was sort of I wouldn't give it a Grammy, but it was definitely recognizable as being our style, and then you get the whole style discussion. But it's so I was expecting it to say I cannot do this because this will be a copyright infringement. I've had that as well when asking for certain songs, like, can you write me something in the style of ABBA? And then he said, well, no, I'm not allowed. He didn't do that with my. I'm saying he. I don't know if OpenAI is he or she or they.
It.
To be honest, it. Yeah. Let's not humanize it any further, please God. And so I know it's in there. I know it's being worked on because it recognizes my music and it can create lyrics and probably a song if I go to Suno or Rudio as well in my style. So it has been trained on. I have not been notified. That's basically the short answer.
Because if I remember correctly, in European copyright law, there is also the author's moral right, which means that the author should be recognized and that the use of the author's creative work should have been also recognized with the name of the creator.
Yeah.
But that doesn't seem to take place now.
No, the question, of course, is if that's necessary within this context. I believe there's a basic principle being used now in the United States whereby they say you need credit, compensation, and a third C, I'm forgetting it right now, but it's at least the credit part is very relevant, that you need to be credited for the work you do, and that indeed is the moral right issue.
Yes.
Yeah, compensate, thanks.
Consent.
Yeah. Consent.
Consent.
That one as well, yeah.
Consent, yeah.
That makes perfect sense, so.
So all
I
three C's are absent.
They're basically all absent at this point. The moral rights issue, and you don't want to go into that wormhole because it's different in Europe than it is in the United States or in Anglo-American territories. But I think especially in Europe, it's pretty relevant. And that one is also not only in copyright law, but also in European charters, by the way. So it's a generally accepted concept, at least in Europe, that you have a moral right to be credited and recognized as a creator of a work, yeah.
Yeah, so moral rights that don't really come home, right? Let's move on, and obviously we have to touch the funny issue of trade secret. A very important trade secret is the recipe of Coca-Cola. As you know, it's very famous. But still, when you look at the Coca-Cola bottle, there are the nutrition labels, and you will realize that's a lot of sugar, unless you buy the diet, but then there's a lot of other things. But this nutrition label is interesting because it's something that is required under also European Union law, that you can say as much trade secret protection as you want, but the users, the consumers of groceries, of drinks and food, they must know what is inside because of allergies, but also because of this information is something that consumers need for themselves. I also checked recently that when, for example, pharmaceutical development takes place and they are doing patient trials, that when the public permit or the public authorization happens by the European Pharmaceutical Agency, which is based in Amsterdam, that they also have to give access to the clinical trial data, because otherwise nobody will be able to actually check that, peer review it, and see that this is actually sound, the testing, that it uses AB, and all these details that are necessary, not just believing in the license, but having more information around. Now, I wonder how far this can actually also carry in the context of training data of AI. And my question here is, and maybe I would like to pose that to you too, Yordanka and Zuzanna. My question to you is, how do you see that trade secret protection should be factored in, and how does it affect the summary, and what is actually trade secret? What does trade secret protect in detail?
Okay, let me start. So first of all, I'm not a trade secret expert. So when I first heard trade secret, I was like, ooh, there might be something there, right? But I am a trained lawyer, so I had a look at the provision. And for those of you who are not familiar with that article from the European Trade Secret Directive, and the way I understand it, that there are two basic processes that one needs to carry out to assess if it's a trade secret or not. So the first process is to see if the conditions under the Trade Secret Directive are met, and there's three of them. So the first one is the information needs to be secret. I mentioned that already, and I have a problem making sense of these companies using, on the one hand, information available on the internet, information that is public, and then claiming it's secret. Okay, maybe somebody else can help me with that. Then the second condition is that the information has commercial value because it's secret. And here we keep saying that we are not actually asking for the data itself, we are asking for information about the data. So we're asking for the metadata. And I think this analogy with ingredients is a good one here. And then the third step is that that there are reasonable steps to keep that information secret. I mean, they're trying really hard to keep the information secret, but I don't know if that condition is at all met either. And the important thing is that these three things need to be met all together, all at once, right? So it's not pick and choose. But then the second process that one needs to carry out is to ask, then there's this explicit mention of that in the directive, that trade secret shall not be protected at all costs, right? It's not like trade secret and I'm free, like free get out of jail card. There can be other overriding public interests at stake that warrant the disclosure of information. And here we go back to what I was previously talking about. In our opinion, the overriding public interests warranting the disclosure are basically the fundamental rights of people whose data may be included, and also the people who may be affected by that systems when they are used in different contexts. So I think that trade secret argument is like the first thing the AI companies try to convince everyone else that they cannot disclose any sort of information about, as I said, either data or other resources they're using. But when one looks at it closer, it's not a very strong argument. So I wouldn't be even as non-expert afraid of pushing back against that.
Mm-hmm. And there was also a special paragraph in the Trade Secret Directive, I remember vaguely, about that it shouldn't affect the right to access of a data subject under the GDPR. So I think the law strikes already a balance here directly. But it is, of course, difficult because you are sitting on the hot chair to actually make this balancing exercise and decide when does the trade secret argument have value and when we have to request this transparency and say that this is not the case here or it won't affect trade secrets. So how does that work out, and do you have already some experience with this trade secret, how to argue with the providers?
Yeah, no, indeed the topic is quite complex, to be frank with you, because they are the three conditions, and as I said before, we see that a lot of companies don't disclose at all any information about this, and we see how hard they really try to keep it secret. So many of them, indeed, we've been talking to a lot of providers, of course, the bigger ones, but even smaller European ones, who see a lot, mainly their competitive advantage coming from the specific sources of data that, as you know, the good quality data makes the important difference of your model performance. And given all the competitiveness now in this area we see, and especially the bigger ones growing, there are indeed concerns, and I'm really happy that we have the open source community a bit to promote the need for transparency, but in our discussions we do see it a lot from all sides, especially also the European ones who are also concerned that given that bigger providers, especially outside Europe, they might choose not at all to disclose, to put their models on the European market or put it elsewhere. But those who really need to operate in Europe have to really disclose everything, and then they see that they can be just overtaken, and indeed their only value that comes from some resources will just not matter anymore. So just to say that there is a strong, quite strong resistance on this topic to share very concrete details about the exact sources. As we said, we've made a proposal already, even for some things like we fully agree being the data a bit publicly available. So in our proposal, we've really tried already to make some granularity of the disclosures that comes depending on the type of sources, for example, and determining how much this information is sensitive, because that also comes with the balancing exercise of how much actually it will help someone to enforce their rights compared to the trade secret and competitive advantage it gives to the providers. And then, I think depending on the different sources that we have seen, there is still quite some concern from the bigger ones who say that, yes, this is really, including like things, even you said the nutrition labels, we also put it there, just be also a bit more transparent how much actually you've used from the scrape data compared to other data or the users' source data that you have your own users and this is not publicly available. And for many of them, this is really, they've invested a lot, a bit I'm sharing the claims, right, in the exact formulas, exact composition, finding the sources of the data that really makes their model well-performing, because as we said, there is a very direct link and they strongly protect and don't want to disclose. So it's a very, that's why I said it's quite complex. We are obliged to somehow, by the legislation itself, to take due account of these trade secrets. We are trying to find and push more for transparency while still also taking into account also a bit the concerns and how much this can help and is needed precisely to disclose certain information in a more general way and aligned with our obligation also to be comprehensive, to facilitate, but at the same time, we also have the constraints and we are still doing this analysis because also some requests that go to the other extreme, that everything has to be publicly disclosed, all the sources, and that's not completely also to our task to prepare a summary to be simple, effective, and the other considerations at stake.
Yeah, that seems for you, you're really sitting in this tension, of these different interests, and yet it is very important. Did you also become a trade secret expert on the way?
I think we are becoming experts on many things, so I'm indeed lawyer, but we also work very closely, of course, within the Commission service, and we have the Trade Secret Directive that is part of another DG, and all the services are also very closely involved. So, yes, that's why we also take time for the analysis.
Thank you so much. I'd like to talk with you, Lucie, about the Hugging Face is a platform, and you have also many data sets on the platform. What are the rules for reusing the data set? Is it for any purpose? And do you actually monitor at all if somebody scrapes Hugging Face, let's say, for taking down all the data?
Right. So the datasets are uploaded by the community, so they can add licenses as they see fit. We have a list of like suggested licenses that are more open licenses, but they can be licensed with conditions as well, right? So one could say you can only download my dataset if you use it for that specific purpose. For models, for example, we had the RAIL license, or Responsible AI license, where we try to out a license that by definition wouldn't be open source because it has a usage restriction where people could say, I want my models to only be used in this kind of context. So the same would be theoretically possible with data sets. I think that in our context, it's always really important to emphasize we are not enforcement agencies. So I think that's when I go into those discussions, platforms often get like very easily fallen into that category of like, why don't you just check the data sets? And we, of course, don't have the capacity. It's still a startup. But also, I don't think we should be in that role. I don't think that a startup should get to decide what kind of data sets should be or should not be used for AI training. And there is also just as I said, the platform doesn't exist in an empty space, kind of. There's this community around it where people actually do discuss what should be in this data set or flag to each other, hey, actually there's my kind of, there's my image in your data set, I don't want that, can you take it down? And a lot of that is just resolved inside the community. Of course, there's a way of escalating this to our trust and safety team, who do look at the legal cases, but there are also a lot of like gray zones because we do operate internationally, right? So there's a lot of questions around something might be morally not ideal, but legally not problematic, and a lot of that then has to be discussed in the community. And it's really, really fascinating to see, right? Because we're at this point where those discussions can happen. And I mean, I'm a big open source enthusiast personally also. So I always think that I'm really scared that we get to a stage where people are really, really scared to upload their data sets, as I said previously. And we saw that case of the photographer in Hamburg that sued the Lion dataset because his copyrighted material is in there. And while I'm very much pro opt-outs and like you should only train on data where people did not explicitly withdrew their consent, it is also a situation where that person could not have sued OpenAI because they wouldn't have had the access to that data set. They could only do that for open data. And I think if we get into that situation in Europe where we constantly have law cases against open data providers, there will just be no incentive to upload your data because at the moment the incentive is not much more than big credibility with the community, right? So I think that's really important to not de-incentivize this by accident because it just wasn't in the discussion.
Yeah, I agree. I remember also this Hamburg case where, in fact, the Lion data set provider could rely on a scientific exception because it was a university that developed this tool, but then it was commercially used. So we are also sometimes here in a difficult place. Wikipedia. You are also very interested in this topic. So Wikipedia content is a very important source of training data. Would you like that this is published and it is probably also legal completely because Wikipedia has an open license and the text claim. So would there be anything that actually speaks against writing, I took all the content from Wikipedia in a public summary?
I think this is where we get into a really interesting part because there is only so much content on the internet. So while the providers say there's this a big secret of what kind of data they scrape from the internet, there's only that much data and you need a lot of data to train a foundation model. So we kind of can guess what kind of data is in those models. And Wikipedia, for example, definitely will be in all of them. So there's not really anything that speaks against them disclosing that information. But I do understand the incentive of the providers to just say, well, we don't give you anything because, you know, you want us on your market. So I think that's a bit the push and pull, and we all are not very envious of Yordanka's job at the moment to find out what's the right situation here. But I do think that exactly as you say, there are certain data sets that you're allowed to use, and we know because the beginning of the research around AI models started with these data sets, and there's no need to take them out now, especially since they are used like that. I think in the context of this community-built knowledge, there's much larger questions around like what does it mean if we consume all our knowledge through AI models and so on, but that's more of a philosophical, my research world question that, you know, we can discuss after the panel maybe.
Okay, so it's always then getting a bit tight-lipped maybe about what information to disclose when it's not so obviously legal, this data set, but it's just a side remark. I think it's a good moment to open up for questions with the audience, and this is going to be the following. You would please be invited to come here in front because we are recording the panel and the walking microphone didn't work so well. So if you have a question, if there are any, which I hope, then please come here in front to the little pult and pose your question here. Yeah? Are there any questions? I have so many. Yes, please. Would you also say who you are, please?
Yeah, sure. My name is David. I work for the Department of Economic Affairs in the Netherlands. And I had a question with regards to these transparency requirements and the summary of data for these new generations of LLMs that are being made, which are AIs that are learning from other AIs. And although these AIs are not as good as the ChatGPT models or others, they are not primarily learning on the basis of data, but just by learning from other AIs, which makes this whole discussion, I guess, a bit more complicated. So I'm just interested in what are your thoughts about it? Are we just like referring to the data sets that are used from the senpai, so to speak, the big AI? How do we address it? Thanks.
Thank you. That's a brilliant question. Who is feeling competent?
I think we came across this situation when we tried to test the template, but maybe Yordanka can say.
Yeah, no, indeed, that's a very relevant point because we see that's why we try to actually identify main sources of data that can be used. So you could have all these publicly available data sets, but you could have also licensed content, users' data that some of the big platforms have themselves. And then you could have indeed other sources like synthetic data or even using directly models to somehow train the other models through other techniques. And that's why we've tried to identify and then propose at least some information and transparency. Have they used this kind of synthetic models for model distillation, for example? We've even proposed also even the name of the model, because it could be quite relevant if you know that some of these models have been already trained on copyright infringing content that actually you might have as a further person possibly affected also from this model, your rights, you could have a relevant interest to know that information. So we are aware, we've proposed it. I think still companies see it also as sensitive, I would say, as many things. But it is, especially for the future, I think quite relevant.
Yes, thank you. And of course, this requirement for this summary will only apply to general purpose AI models under the AI Act. So not all AI systems that are governed by the AI Act are actually addressed by this requirement, only these general purpose AI models. And if I understand that correctly, the development of the AI system itself, if does not yet, before it is put into circulation, right, is not yet covered by the AI Act. So what is the moment when this summary has to be made available? That was a question I sit with since a while.
Yes, indeed. So the AI Act is a market-based legislation. So the moment you place your model or general purpose AI model or AI system on the market, that means that it has to be fully compliant. So obviously you have to take some steps before to ensure that compliance, like the documentation for the model or the training data, and then the moment you place it on the market, and this is what we are also planning to clarify, that has to come indeed with the relevant summary also attached to it. And we think that's quite important also to keep it also up to date, or also even to always have the summary through the distribution channels, how the model is provided.
Yeah.
If I remember correctly, but Lucy, correct me if I'm wrong, there's this exception though in the AI Act that placing models on platforms such as Hugging Face, I mean the AI Act doesn't mention Hugging Face, it's not in itself placing it on the market, right? Because otherwise that would be a huge obstacle for open source community also to assess the models and work with them.
Yeah, this notion placing on the market is important indeed. So it's not automatically that you are considered that you have placed, but there is an assessment as part also of just the product legislation that applies in general, how, for example, even making these models accessible to European users could be considered, but it's not that that you just place them. Also, if you are also even for non-research, for research, for other purposes, it doesn't mean that automatically you are in the scope.
Yes, yes, that's right. But it also means that there is, when this development phase takes place, which is not yet in the scope of the AI Act, but that's when the data is put into this model, yeah, to train it. That actually then the transparency happens after it happens, if the market placing takes place. Yeah. Okay.
Yes, because we cannot, in a way, make these obligations prior to an actual model that exists. So
yes. Is there more? Please come forward. You can also already, if you want, stand behind each other. Say who you are. Also, to whom you address the question.
Yes, thank you. Luca Bertuzzi, MLEX. My question is for Yordanka. So I was wondering why the Commission decided to link the discussion around the template to the code of practice of general purpose AI, because the GPAI code of practice is co-regulation exercise led by independent experts, as you say, and normally model providers are more involved because they are those who should sign. So some right holders were complaining that this discussion took place there because the template is a mandatory document that the Commission has to issue. So what is the relation between these two processes? Why have they been linked? And also recently the Commission has said that the template will be accompanied by guidelines. Why exactly do you need guidelines to use a template? What will be the guidelines about? Will it be about the IP trade secret protection and so on? So if you could clarify that, thank you.
Thank you.
yes, thank you very much. Indeed, very relevant question. So the two processes are clearly distinct because the code of practice is written by independent experts with many stakeholders involved. So the Commission only ex post assess it, while the template is indeed under the Act, we have to develop it. So we've organized public consultation that already provided us input to this, but we have more than 1,000 stakeholders involved in this code of practice process. If there are companies here or other right holders, they know the complexity of this exercise. So actually we do have, in terms of stakeholders represented, the providers are even a minority because we have many organizations of right holders, we have experts, we have civil society, we have academia. So with all these stakeholders who have actually, because their processes are independent, but still for right holders and for other actors, because we also have obligation for documentation. So as you very well know, there is also the part of the general documentation and transparency related to Article 53, 1A and B, that is also discussed in the code. So it was relevant having the whole this community that it's rarely combined, that we could actually consult them and also present the initial proposal and collect their views. So as we've received the replies, we still see that actually the providers are still quite minority, and we've also a bit reported, we have all the stakeholders having given input to that process. And we haven't given just to someone being able to discuss or steer the process. That's why it was just a sort of consultation to receive, and the feedback was clearly very balanced, and even I would say more from the right holders. We see just because the two communities are so affected, also providers, they also try to express their views in that, and we haven't organized anything else, or no one else is leading this exercise than us. So that's very clear. On the other question for the guidelines, indeed, because the template is the template. This is what they'll have to fill in. But then there are important things that have to be clarified, indeed, how we have made the choice with the balance, and with the trade secrets, for example, that's very clear. Something that has to be expressed. There are also other things, for example, when to publish the template, how to make it public, do you update it? So with that information, what rights, for example, of persons with legitimate interest, what are the objectives of the template? So all these relevant explanations that somehow explain the choices in the end made, and also how to implement it in practice are relevant, and they will be more in the introductory part to which the template will be annexed.
Thank you so much. Please.
Perfect. Hi, thank you very much. My name is Handa Uskagan-Prendel. I'm a researcher at the University of Vienna. My question would mainly go to Yordanka and Zuzanna. I was in a panel just before that was about the enforcement of digital regulations and the role of civil society, and there it was heavily discussed with respect to Article 40 of the Digital Services Act, how it's so difficult for researchers to gain access to data, to be able to check that how the enforcement of the regulation is in place and to assess the systemic risks. I'm aware that, Zuzanna, you said you're not asking for the data itself, but metadata, but I was wondering whether that push and pull with the big tech companies and the experiences with the enforcement of the DSA has influenced the drafting of the template. Like, were there any considerations from that side that you had to take into consideration as to how you can go through this obstacle with respect to, like, that is posed by this trade secrets as a big word, as Zuzanna, you were saying, it doesn't hold much, but I'm still wondering that de facto these companies are trying to really push for not sharing anything. So I'm just wondering whether that process has paid into what you're going through right now. Thank you.
Thank you.
So maybe I can answer very briefly. I think the experience with DSA in many respects, with including the access, the researcher's access, but also the whole process around the code of practice is somewhat similar. But I think that taught us the importance of researchers to be able to access data. Of course, here it's somewhat different. The template is, as we know, is a summary of the data. But it should create an opening for researchers to be able to take next steps, right, and to be able to inquire. I really believe that this is absolutely necessary in order for these tools, for these services to be basically safe. We've learned with social media how unsafe that can get and what problems that can lead to. So I think, it's an important lesson with research about research ethics, about the role of academia and the impact of new technologies that we should not forget.
Yeah, I can only compliment that indeed, in the end, the summary should also facilitate the work of the researchers. Because there are sensitivities in the information itself, including commercial value details, but even in some cases security aspects, that's why there are different models, how you enable this research. In the DSA, there is this very concrete provision. There is a very complex, well, not complex, but in the sense of detailed way, how access can be given, under what conditions, and so on. In the public summary, it's available to everyone. So that's why it's much more simple. But indeed, what you disclose for everyone to know it, including your competitors and so on, is then a more difficult choice to make in the final information that is publicly disclosed.
Thank you. That will be the last question, but please.
Yes. Thank you very much. I'm Max. I work with Mozilla. We mostly know each other. I have a question, but before that, I also wanted to point out the irony, because we discussed distillation of OpenAI now considering legal action against DeepSeek and complaining about distillation, but them not being able to prove it because there is no transparency about how DeepSeek came up with its synthetic data. So yeah, there is some irony to that. My question to Yordanka, I'm sorry, you get all the questions. And you already mentioned both things, like the trade secrets part and the security risks, right? One of the things that I've found personally very annoying is that obviously we've been engaging with the Commission, we've been trying to engage with companies, we have not received a lot of sincere engagement back from companies and trying to counter arguments, because the two claims we always see is everything's a trade secret and everything's a security risk. But obviously that doesn't really work as an argument, right? Because the debate is not, is there a template and a summary, or is there no template and a summary? But it's, what are the different data points in there? So because you've received all those arguments from companies as well, maybe you can talk a little bit about what specifically they actually think is a trade secret, what information specifically they actually think causes security risks, because obviously there is a big difference between disclosing a list of URLs and disclosing information about, we used this tool for anonymization or this process for cleaning data. And maybe there's legitimate arguments about security risks, but no one's really made them in public yet. So I'd be curious to hear whether you can share some of the thinking there. Thank you.
Yeah, well, so first, this filtering, curation methodologies, all this information, as we know, a lot of sources are available online, but how you actually treat them, how you filter them, how you curate the data so it becomes a quality data set to really make your model function well is something that is clearly something that the providers really concerned as very sensitive commercial information that gives them exactly the competitive advantage to it. Some of for the security risks, especially a lot of the claims we've seen is that having full information about all the different data sets, even the composition between different sources, like I've also wondered about this, but knowing that you've used 10%, for example, from publicly available sources compared to 15% licensed data and so on, is also seen as very much commercially sensitive, exactly part of the secret recipe and formula of how you combine the data and what you do with it. And the security risks, especially when you go into the actual sources of information, like already disclosing we have these also the large data sets that were mentioned, like if you have used, for example, Lion, it's already in the recital that we try, and that's why we really try to stick to what we have. When you ask them to disclose this, yes, they also some say that disclosure of all the URLs, but also even these large data sets, can lead to this adversarial engineering, reverse engineering of the model, and then opening security issues with the model itself, and replication of the model in other settings. So I'm just sharing with you a bit all the arguments put, but they are much more elaborated and yeah.
So with this, we actually have to wrap down, and I want to give you the chance to say in one sentence an important message you still want to share. I have also a sentence, if you don't mind, as moderator. There is some magic happening with generative AI models. Even if they are illegally trained, we wouldn't know, but what comes out is legal. Would you?
Right. I think, as I've said throughout the panel, I believe that we know it's very possible to document this data, and that it's not only crucial for researchers and for further developers to understand what is in those models for society at large, but also so that we protect an open sharing and continue a healthy development of AI where we all have a voice and understanding where are we going, and do we want this?
Yeah, I'll sort of unfortunately repeat myself and say, like, if the data is that important to train on, if it has that great a value, as we all know, we should definitely look at, and as a society, be aware of what the data is that's being trained on, and from a creator perspective, get some sort of recognition, remuneration for that. So the importance of the data is leading in all aspects, I believe.
Yeah, from my side, I just want to thank your panel, but also the participants, everyone indeed trying to push further the debate and really to emphasize the need for transparency to help us in striking that careful balance, including to further try to change the culture that we see, and also in terms of also dialogues with providers and support for more effective and transparent development.
So for me, besides saying that and believing that transparency does serve fundamental rights, I think the lack of transparency only serves incumbents, and it never really serves innovation. So if we care about innovation in Europe, we should be for transparency.
Thank you, thank you. And with this, thanks to the panelists.